Can't take away my rights, period, anyways. My rights are inalienable, sir.
Next, we're in Phoenix, Arizona, where Michael Crane, a self-identified sovereign citizen, has requested to change his plea from not guilty to guilty for just a few of the many charges hanging over his head. The 38-year-old's facing 3 counts of first-degree murder in a separate case for allegedly shooting 3 people to death inside their homes during 2 separate robberies. But today, he's pleading guilty to lesser charges of burglary, theft, and weapons misconduct in 2 cases unrelated to the alleged murders.
Mr. Crane, it's my understanding that you wish to change your plea.
I've already told you that I'm willing to accept responsibility for all these charges. So that is what I'm telling you right now.
You're giving up your right to a jury trial where you'd be represented by a lawyer. Do you understand that?
I understand that, but I don't agree with that.
You're giving up your right to cross-examine or question any witness the state called. Do you understand that?
I understand that, but I don't agree with that.
To say Crane doesn't agree with the legal process is an understatement.
Do you understand that if you plead guilty, you're giving up constitutional rights?
Which U.S. are we talking? Are we talking about the federal constitution of the District of Columbia, that U.S. Constitution, or are we talking about the states of the Union common law constitution?
For nearly an hour, Crane spouts more sovereign law ideology.
I ask you again, are we working under admiralty law, under statutory jurisdiction? Let the record show that Mr. Crane is a sovereign man born in the states of the Union. My rights. If you're calling me a person or a domicile or an agent in the District of Columbia, sure, you can take away my rights, but I am neither of those.
Finally, he does enter a guilty plea, which, if you can remember, was the whole purpose of the hearing.
It's a choice to trial or a choice for me to accept your plea. Given that choice, which would you prefer?
The choice to accept the plea only under my conditions.
And just when it looks like the hearing was going to end, it doesn't.
I'm not going to sign a contract that's going to send me to prison, not voluntarily.
Crane argues he won't sign any legal paperwork to make his guilty plea official.
Are you saying that you have the authority to force me, a sovereign American man, that's going to send me to prison? Because this is what this comes down to at the end of the day.
Yes.
Wow, okay. Thank you. That's all I wanted to hear.
Ultimately, Michael Crane would affirm his guilty plea for the charges of burglary, theft, and weapons misconduct. But before he's sentenced for those charges, Crane pleaded guilty to numerous other crimes, including the 3 counts of murder. That plea came as part of an agreement with the prosecution, where they took the death penalty off the table. He was later sentenced to 3 consecutive life terms in prison.
7 William Dennis.
For our next story, we head to Kauai County, Hawaii. The defendant is William Dennis, who's in court without a lawyer to face the charge of driving with a suspended license.
Good morning.
All eyes are on Dennis as he approaches. Clad in a blue robe and a headpiece, he immediately addresses the court.
Well, my knowledge of the facts is with this claim of this standing with this microphone,
Sir?
of the documentation with the
Sir?
continuation of the evidence
Sir?
by this peaceful volition.
Dennis has been rambling for more than 10 seconds now, but the judge allows him to continue.
Sir, unless you stand there, you're not being recorded anyway.
For the claimant's knowledge of the facts is with avoidance of the boxes and planes with this closed area-court room by the unity-consciousness.
Dennis obviously has a thing for hyphens, so the judge attempts to get things back on track with a simple question.
Okay, what's your name?
For my knowledge of my peaceful volition is with avoidance of the perjury, with this participation of correct sentence structure communication passe syntax grammar.
If you're counting at home, that is 7 hyphens in just that answer alone. Thankfully, the judge steps in.
Okay, well, we have a lot of folks waiting here, and I would hope that you would be courteous to the other human beings that are in the courtroom today, waiting their turn to be heard. What do other human beings call you?
For my knowledge of the facts,
Perhaps hoping to avoid an extended answer, the prosecutor chimes in.
Your Honor,
Okay.
he is known to the state already as,
William M. Dennis.
Yes, as
The
Mr.
court-
Dennis.
The court will find that I know him from prior occasions.
this is going to be dismissed with prejudice. However, in order for his driver's license to be reinstated, there are reinstatement requirements that he must fulfill at licensing.
Okay, Mr. Dennis, first of all, I'll grant the motion. It will be dismissed with prejudice.
Okay, thank you.
Dismissed with prejudice means the case is permanently over. Done. Finished.
Mr. Dennis, I believe the state is being very patient and tolerant with you. You're free to go.
Thank you, Mr. Dennis.
It seems everyone wants this case over. That is, except for the defendant.
for my knowledge of my peaceful volition, with this calling of the cooperation
Sir?
with the human
Sir?
beings of this court-room,
You're being
with the
disrespectful.
creation of
Dennis can't quite see the gift he's been given and throws out a few more hyphens.
mind-body-healing and organic-food-growing,
Sir,
with the free of the cost, with the
please have a seat at the front.
of the cost,
Please.
with the
It takes some assistance from the bailiff for Dennis to get the message. But on his way back to the gallery, he gets a few more hyphens in just for good measure.
mail-livery by the correct sentence structure communication passe syntax grammar.
Sir, please have a seat in the front row.
This man is probably one of the most dangerous men that I hope to ever encounter.
Next, we go to Muskegon, Michigan, for the sentencing of Jeffrey Willis. The 48-year-old was convicted of kidnapping and murder in the deaths of 2 women. 36-year-old Rebecca Bletch and 25-year-old Jessica Herringa were killed in the span of 15 months in Muskegon County. Police had no viable suspects until 2 years later, when Willis was arrested for abducting a 16-year-old girl who was lucky enough to escape and report him to authorities. When police searched Willis's home computer, they found images of both Rebecca and Jessica in a file called VIX. Willis was charged in the death of both women. He pleaded not guilty, but was ultimately convicted.
People versus Willis.
At sentencing for the Bletch murder, Willis's attorney makes an unconventional request on behalf of his client.
We are hereby requesting that my client be allowed to leave these proceedings at this juncture. He has informed me that that is his desire.
Prosecutor DJ Hilson shares his feelings on Willis's request to avoid facing victim impact statements from the Bletch family.
It's unfortunate that he's choosing this cowardly way of doing it. You know, that being said, whatever the court decides, the court decides.
Judge William Marietti allows it. And with the victim's family voicing their disapproval, Willis leaves the courtroom. But as he steps through the door, watch as he blows a kiss in the direction of the Bletch family. A year later, Willis appears for the sentencing for the Herringa family, but this time the victim's family chooses not to attend, so he decides to stick around.
Mr. Willis, do you have any additions or corrections to it or anything that you'd like to say?
I have something I'd like to say right ahead. I came here today with the intention to finally speak up and set the record straight.
Willis would then take the next 13 minutes to discuss a slew of topics, starting with the kiss, which he claims was not intended for the Bletch family.
So I want to start by apologizing to the Bletch family. My blown kiss that was spitefully garbled by the press as a rebuke to the family was in fact meant as a message to the prosecutor, DJ Wilson. That message being that I'd figured out the truth and that he can kiss his future goodbye.
Willis then went on to accuse the Muskegon County Police of fabricating evidence and committing perjury before directing his ire at the jury.
I along with these 5 jurors who couldn't even stay awake long enough to listen. They were more concerned with placing the blame and seeing the salacious evidence that was put before them by unscrupulous news organizations. Clearly to all these members, these trials were just an exercise in feudalistic justice. Catch them, flog them, imprison them.
Finally, he segues into the U.S. Constitution.
The Constitution of the United States has in its preamble, "We, the people, in order to form a more perfect union, establish justice." This promise, made over 225 years ago, remains unkept. I am innocent.
Since no members of the Haringa family are present, Judge Marietti offers the prosecutor the final word.
This man is probably one of the most dangerous men that I hope to ever encounter. He shows no remorse, no ounce of dignity or integrity. And it's clear that the justice system has the right place for him, and that's behind bars for the rest of his natural life. We have successfully locked up an individual who, had he not been caught and captured, would have continued his killing in this particular community. And so, with that, Judge, I'm going to sleep very well tonight, knowing that Mr. Wilson knows the light of day. Thank you.
After the applause from the gallery subsided, the judge announced his sentence. Life in prison plus 18 years, with no chance of parole. Willis appealed the decisions in both cases, but his convictions were upheld.
Anything else you wish to tell me, sir, regarding your bail? This conversation could endanger my life, your life, this guy's life, any officer in here's life.
Next, we go to an arraignment in Allegan County, Michigan. The defendant is 32-year-old Joshua Duimstra. He's been charged with possession of methamphetamine. This is Duimstra's second drug offense. If convicted, he could be looking at 20 years in prison. The judge today is Joseph Scotchless.
Are you Joshua Duimstra? Yes, I am Joshua Kevin Duimstra.
Getting things started is the defense attorney, Dario Sierra.
Your Honor, I attempted to have a conversation with Mr. Duimstra in regards to these charges. Unable to have a meaningful conversation, I'd ask the court to arraign him at this time.
With the defendant and the attorney not appearing to be on the same page, the judge continues the hearing on his own.
Because of that prior drug conviction, they have charged you as a repeat offender. As such, this is a felony charge. Maximum penalty is 20 years in the state prison and/or a $30,000 fine.
The judge goes on to explain the defendant's rights before offering Duimstra a chance to speak.
Anything else you wish to tell me, sir, regarding your bail? I'm not going to take the blame or plead guilty to something that isn't mine. I mean, you're not going to work for Homeland Security and then try to come at me. I work for Homeland Security teams and other courts and stuff like that, and for the law and military and U.S. Supreme Court, and make it seem like I'm the bad guy, because I'm not. This guy here, Dario Sierra, he says that I wasn't compliant on the phone this afternoon. That's a lie. I've been very kind. I've been very respectful. I refuse to be a criminal. I am not a criminal. I am professional, just in a different way. I am me. I'm for the courts, for law, and above, also all military and above military. I already talked to a lot of important people that work for the government and federal government.
While the judge and defense attorney listen patiently, Duimstra wraps up by claiming that his drug charge is the result of him being an undercover agent.
I am 100% undercover, and I've been working on other cases to investigate, to get in close for SWAT, for CIA, FBI, DEA. This is not an illusion. I have witnesses. I have the state. I have other states. I have governors. I have mayors that are on my side. This conversation could endanger my life, your life, this guy's life.
Over 8 minutes later, Duimstra finally wraps up.
Whatever it takes to help you understand that, I hope my words did. And that's the God honest truth, so.
The undercover claims proved to be false, and the judge sets Duimstra's bond at $1,000.
Condition of bail, do not possess or consume any alcohol, marijuana, or controlled substances.
The Public Defender's Office is being appointed to represent you in this case. But with that, you're all set today. Good luck to you, sir.
Also, could I say one more thing?
Thank you, sir.
You're welcome.
Duimstra has yet to enter a plea and remains in jail. The results of his case are pending. Next, we head to a bond hearing in Orangeburg, South Carolina. The defendant is 26-year-old Dajour Maurice Hall. He's been charged with attempted murder, possession of a weapon during a violent crime, and possession of a weapon by a convicted felon in connection with 3 different shootings. A few days earlier, Hall was arrested after he allegedly shot a man in a crowded nightclub. Police had already been looking for Hall because of 2 other shootings, including one at a home where a 3-year-old was present. Today, Hall appears before the judge in hopes of making bond. Also present are representatives from 3 different law enforcement agencies who all want to see bond denied. Right away, Hall does not seem happy to be there.
Man, get me out of the car, man. I don't even want to be through this shit. Something gonna stay about me, boy. You started it, nigga.
Mr. Hall.
I ain't do nothing to you. Boy. Man, I don't give a about none of that. Boy. It ain't over with. You boy. You started it. You gotta go on me. I'm not that boy.
Hall's removed from the court and given a chance to calm down. After a few minutes, the judge decides to give him a second chance.
All right, let's bring them. Let's bring your victims back.
The defendant appears more respectful this go-round.
All right, Mr. Hall, if I am to do bond today, understand that I'm putting a no-contact order between you and the victims and any members of the victim's family. The contact means, of course, no third-party communication, telecommunication, or written communication. You do realize that if you violate that order, you will subject yourself to sitting in jail until this case is fully adjudicated. You understand?
Yes, sir.
So far, so good.
All right, anything from the state first?
Yes, sir.
From Bowman first? Yes, sir.
Due to the severity of the crime that has been committed and his extensive record, we would like to ask the court for no bond. We feel that he's a threat to the community, Your Honor.
And from you, sir?
The judge allows a representative from a second law enforcement agency to speak.
Your Honor, we've got numerous convictions on his criminal history, not just South Carolina, but also North Carolina. He's got a very extensive history, as you've heard from Bowman. Some of the highlights are burglary, as you've heard from probation parole, several assault charges, possession of weapons with convictions. Your Honor, this is a very serious act. Not only just our charges, but Bowman's charges. We're asking for denial of bond also. We feel like that he is a flight risk. He's got ties to North Carolina, as well as he's a danger to the community.
It's now up to the judge to make the final decision.
Mr. Hall, based on what I'm hearing, I do feel that this court should defer your bond to be set over in General Sessions Court as opposed to me setting it today, which means that you will be going before the General Session judge in order for that judge to set your bond. You understand me? So
yes, sir.
This particular time, we're going to deny the bond on Hall. Thank you very much.
Hall is denied bond and for now must remain in jail. And with that, his civil demeanor quickly disappears.
You understand me? So
yes, sir.
This particular time, we're going to deny the bond on Hall. Thank you very much.
Hall makes a few more comments as he exits the courtroom.
I don't need me standing here, man.
Hall would later take a deal from the state and plead guilty to discharging a firearm into a dwelling and 4 counts of first-degree assault and battery. The other charges, including attempted murder, were dropped. He was sentenced to 7 years in prison with credit for 863 days already served.